SJC-11556, Commonwealth v. Mikolai K. Letkowski.
May it please the Court, I'm Charles Rankin and I represent Mr. Letkowski. We're here today on further appellate review of Mr. Letkowski's claim that Doyle-Motti era infused this trial and created a substantial risk of a miscarriage of justice. While the most egregious example of what I contend is Doyle-Motti era occurred in the closing argument when the prosecutor referred specifically to the defendant's exercise of his right to silence, I suggest that when reviewing the entire record, you see that this theme that was driven home in the closing, that the defendant calculated his every action both during the crime itself and in his interaction with the police after he was arrested.
What were the issues at trial?
The issue was criminal responsibility.
Not voluntariness of the statement?
Voluntariness was an issue.
Okay, now the evidence that you have focused on in your brief, the Commonwealth suggests that that really was evidence that the prosecutor was using to address the issue of voluntariness of the statement, not the insanity issue. What do you say about that?
Well, that's what the Commonwealth argues. I don't think that invocation of your Miranda rights, your right to silence, has a role to play.
But it was made an issue by trial counsel.
It was not made an issue by trial counsel, Your Honor.
No,
Voluntariness was made an issue, and certainly the Commonwealth could prove that the defendant was given Miranda warnings and understood them.
But the prosecutor or the defense counsel was suggesting that the reason why the defendant went from silence to talking to the police was the fact that he was withheld
medication.
And the prosecutor was suggesting that there's another reason why he might have come forward, having nothing to do with that. And why isn't that proper?
I don't think it's proper to offer the defendant silence when first questioned, when it's a humane practice or voluntariness is at issue, especially as it played out in this case.
So it's because the prosecutor in direct examination of Detective Dean was the first one to elicit, without objection,
the invocation.
Would that have come, is there any indication that that would have come out in any event?
Well, the only other indication of the invocation was during cross-examination by the prosecutor of Dr. Lurie. And so the prosecutor elicited that evidence during her cross-examination.
But wasn't Dr. Lurie also testifying about voluntariness?
To be sure, he was. But he didn't, on his direct examination, the defense lawyer did not elicit any evidence that the defendant had invoked his right to remain silent during the direct examination of Dr. Lurie.
But Dr. Lurie testified that he made the statement because he had been withheld medication.
Well, making the statement, and I mean, I think, let me just try to articulate what the defense theme on the voluntariness of the statement was. It wasn't police coercion in the sense that there were a bunch of police officers and he was questioned for a long period of time. It was that he had suffered an injury between the time he was stopped by the police a day after the crime and beaten and hospitalized, had a broken face, and was given powerful medication. That the medication and the injury rendered his statement involuntary.
And I'm trying to focus on that. I think that may be important. So if I recall, on cross, it was the prosecutor who tried to tie the fingerprinting to, in cross-examining Dr. Lurie, it was after he fingerprinted, right? And that's when he spoke, and he says, my understanding was, well, he was willing to if he got his medication, and then the prosecutor went back to the theme of, well, wasn't it after, and here's the hypothetical, you know, wouldn't somebody who did the, and going on into what somebody would have done if they had been trying to create something.
Well, that's exactly right, and that played into the prosecutor's theme from the opening statement through the examination of Dr. Lurie and the direct examination of Dr. Kelly, and then especially in the closing.
So did the defendant challenge the voluntariness? He testified, right? No, he didn't testify.
The defendant did not testify.
No, okay. So how would you say, in response to Justice Spina, how would you say that the prosecutor should, given the challenge to the voluntariness, what do you think would have been the permissible boundaries of a response or a?
I think it was perfectly proper to establish that the police gave Mr. Letkowski Miranda warnings twice, that he acknowledged that he understood them, that he appeared to understand them, and leave it at that. It was unnecessary to say that he
Changed his
invoked
mind, yeah.
in order to establish voluntariness. They could also explain what they did with respect to the defendant's medication. The defendant had been arrested. His mother gave the officer who arrested him the medication. At some point, about an hour before he gives the statement at the police station, he's given the medication. The prosecutor can comment on the defendant's appearance. The prosecutor can even comment on the nature of the defendant's statement by saying, well, he admitted that he assaulted the person but claimed not to have a weapon. He admitted that he kidnapped her but claimed not to have sexually assaulted her. So those things are fair game. But what's not fair is calling attention to or producing evidence of the invocation and then using that as the denouement of the closing argument. I mean, if you look at the last 2 pages of the prosecutor's closing argument, the theme that the defendant's conduct was calculated both at the crime and then in his interaction with the police is just a nail in the coffin, and that's utterly improper. It's not going, as Justice Spina asked, to the question of whether the statement was voluntary, but rather it's trying to use his silence at first and his exculpatory statement after being fingerprinted to drive home the point, even though the prosecutor says it's his right to do this. I mean, this court's recognized in Cobb and other cases that that is not sufficient prophylactic to meet the 5 factors in Mahdi.
So
the
Mr.
issue.
Rankin,
Go ahead.
I'm sorry.
Oh, go ahead.
I'm really confused. I thought it was the defendant's expert who opined at some point that it was the withholding of the medication that would have basically driven the defendant to say anything, to make any statement. And if that was going to be the thrust of the opinion, was that somehow known through the opening or through sidebar conferences or other conferences with the judge, that was going to be the nature of the expert's testimony? Would it have been?
You're asking if this was anticipatory,
yes,
kind of prophylactic.
Yes.
I think that's a fair question, certainly, but I don't think that's a fair reading of the record. At the outset of trial, during impanelment, the defense lawyer says, I am going to request a humane practice rule, and voluntariness is an issue in the case. Dr. Lurie testifies on direct about the effect of being a heroin addict, having been prescribed morphine or OxyContin at the hospital the day before, and testifies, it's set out in the brief exactly how he testifies, but doesn't mention the invocation during the direct examination. It's in the cross-examination by the prosecutor of the defense expert where she poses a hypothetical that if the defendant invokes and then realizes that he's being fingerprinted and is thinking, damn, I had touched the steering wheel. That's how it was used. And
So you're saying it only came out in response to a hypothetical that the Dr. Lurie was not prepared to opine before that the involuntariness of the confession or of the statements that were made had to do with the fact that he didn't get the pills, and the withholding of the medication was what, sort of, he would say anything.
Well, I frankly don't know if a report of Dr. Lurie was given to the Commonwealth with that information. I don't think, though, that if it had been known that Dr. Lurie was going to say, because he was in tremendous pain and needed the medication, they would have, by giving it, it renders the statement involuntary. I don't think that opens the door to evidence of invocation. This court has been very clear that there are limited circumstances in which one opens the door. Two of the cases are our cases, Tulin a year and a half or 2 years ago, and Adams before that. In Adams, whatever the defense theory was, it was clear that the defense was making great use of making a lot of use of invocation, and the court found that there was not a substantial risk of a miscarriage of justice. In Tulin, giving prospective advice for what would happen, the court cautioned the Commonwealth not to put in the invocation evidence unless the defendant opened the door in some unspecified way.
Let's assume you are correct, that it was not appropriate to have offered this evidence. You identify a whole series of rather calculated acts that the defendant did from the very beginning of this crime. Why would this particular act of calculation be such as to affect the verdict?
Well, I don't think that's the standard.
Well, I understand, but apply the appropriate standard.
Risk standard.
It's a substantial risk standard.
Right.
The court in Mahdi set out the 5 factors. We tried to muster the evidence on each of those 5 factors.
Let's assume you prevail on all 4 except the one, the overwhelming. I mean, here the evidence of calculations just seems overwhelming in terms of all the things between the ATM and where he went, and this is not a crime of. This is a rather calculating crime.
I mean, Dr. Lurie testifies, Dr. Kelly testifies. Dr. Lurie testifies that he has bipolar disorder and substance abuse issues. Dr. Kelly disagrees but concedes it's difficult to diagnose bipolar, that if you have an adverse reaction to treatment, to certain medications, that can be an indication of bipolar, and in fact, Letkowski had that. That ADHD and bipolar have some association, and Letkowski had that. So there were a number of factors that even Dr. Kelly conceded were in play. And Dr. Lurie's diagnosis was basically that the mental illness caused Letkowski to engage in this high-risk behavior,
and very calculated. Leaving the area to go to an ATM machine that wouldn't be going into a secluded area. I mean, very calculated.
Well, the trigger of the assault does not necessarily mean that it is that he's criminally responsible, even if some of the conduct is, in fact, calculated. Or, I mean, there are plenty of cases
that reflect that he understood that his behavior was criminal in nature.
But what? Okay, fair enough. So calculation doesn't mean no mental illness, and could be consistent with bipolar illness, is what you're saying, I think.
Yeah.
But why is this calculation, this category of calculation, i.e. about the Miranda warning, different than the ATM and the where he's, you know, moving to the passenger seat, et cetera, et cetera?
Well, I just think that the court has been so sensitive to the damaging adverse inference that a jury is going to draw from a defendant's refusal to speak to the police, that it said over and over again that except when the evidence of guilt is overwhelming, that the court has used that word repeatedly, when it's overwhelming, you know, we'll say it's not a substantial risk. But I don't, however you can characterize it, and you can identify what steps are calculated, I don't think you can say it's overwhelming when you've got two experts on opposite sides, they're qualified, they're giving credible opinions, and the Commonwealth's expert concedes some of the points about the defendant's mental illness.
So is what you're saying, it's not that it's, the point about this is it's a different category, it's not, what makes it so harmful isn't because it's yet another example of calculation, it's that it's Miranda warnings and giving them up and all that has with it, whether you're got a criminal responsibility defense or not.
Yes, the invocation is a special, as the law's developed since Doyle.
Mr. Rankin.
Thank you. The invocation is important. Thank you.
Good morning, Your Honors. May it please the Court, Assistant District Attorney Bethany Lynch representing the Commonwealth. In this case, the Commonwealth did introduce evidence that the defendant exercised his right to remain silent. The Commonwealth did that in direct response to the defendant's position that he was going to challenge the voluntariness of his statement.
But more specifically, was there any indication that the defendant was going to challenge the voluntariness by a suggestion that it was the withholding of the medication?
There was a very lengthy motion to suppress in this case. I believe it went on for 6 or 7 days of testimony. And part of that was focused explicitly on this statement and on the withholding of the medication from the defendant.
Same expert testified?
No expert testified at the motion to suppress.
Did you have a report from the expert knowing that the expert was going to say this?
I know there was a report from the expert provided to the Commonwealth prior to the trial. It was provided the same day that the defense attorney represented to the trial judge that he would be challenging voluntariness as an issue. I have not read that myself.
But that wasn't the only basis for challenging voluntariness, right? The notion of the withholding of the medication. There were a whole other range of the fact that he had the injury that he was on this very strong medication.
Yes, it was primarily on the fact that and this is the point that I'd like to highlight, is that the defense attorney, the defendant's expert, focused his opinion on voluntariness on the entire chain of events that led him to give his statement to the police, including the fact that initially he declined to do so. So
where did that come from first? I'm sorry.
That came up during Dr. Lori's testimony.
But you had already, I mean, the Commonwealth had already put that evidence before the jury.
It had.
So it wasn't the defendant who introduced that?
No, it was initially introduced. Well, I can say that the defense attorney raised the issue in his opening argument that he wanted the jury to focus on how the police came to get a statement from the defendant. This was immediately following him telling the judge that voluntariness was a live issue at the trial. He raised that. The Commonwealth said nothing about the invocation or the voluntariness of the statement in its opening argument.
But that, I mean, inherently, that's not...
Yes, but it was put out there that was going to be an issue, and he wanted to highlight that for the jury. During the testimony of Detective Dean, the prosecutor did ask him the entire series of questions about signing all the thing, and then Detective Dean did testify that he chose not to talk to them. They then stopped questioning and took him down and booked him, fingerprinted him, and at that point, the defendant indicated that he did want to talk to the police.
But did the defense counsel give an opening statement?
He did, where he wanted the jury to focus part of their attention on how the statement came to be. He did not mention the invocation specifically in his opening argument, in his opening statement, but he did want to clearly that was going to be an issue throughout the trial. And so the prosecutor did put this in. The defendant did not object. Then during the defendant's cross-examination of Detective Dean, he brought up the issue. Well, isn't it true that he initially didn't want to speak to you? Did you know he was on medication? So the defense attorney used this invocation testimony every bit as much as the prosecution did in this case.
It was already...
It was brought in initially by the Commonwealth as a means to explain why the Miranda was given twice.
But I'm trying to figure out the defense strategy here. I mean, I gather in opening he also said the issue is not whether my client did it.
Right, in his opening he conceded that the defendant committed the acts, that he was not criminally responsible, and that he had given a statement that he wanted the jury to focus on how that statement came to be given. I can't speak to exactly why that was an issue, except that there was a humane practice instruction, and he wanted the jury to find that this statement was involuntarily given to the police because he did attempt to exculpate himself in ways that the trial evidence was clearly going to undermine.
And in closing, did he argue that there was not a rape?
In closing, he argued, I'm sorry, in closing, did he argue what?
Did he argue that there was not a rape, but just the conduct which the defendant admitted to?
He acknowledged in closing.
So,
but in closing, he also said, you will see from the documents that you have, he was read his Miranda warnings. He had the presence of mind to request an attorney to indicate that he did not want to speak to the police. And you will see that there's some medication that's provided, and then about an hour later, he signs a Miranda form and gives a statement. So the defendant put that right in his closing argument. So he is also using, I'm not saying that it completely excuses the fact that the Commonwealth introduced it initially through Detective Dean's testimony, but from that point on, the fact that the defendant invoked his right to silence was evidence used by both sides to go to the voluntariness of this statement. I do not believe there was evidence that there was ever a direct argument that because he invoked his right to remain silent, he was therefore sane days before when he committed this crime. His expert testified that initially he had his criminal responsibility was an issue, but that as this criminal episode continued, his expert acknowledged that he did make some very calculated acts and that almost like he was coming back to himself. At some point, he was trying to protect himself, and he did appreciate the criminality of his actions.
So is it your position that whenever a defendant says that voluntariness is a live issue at trial, that opens the door to your offering the invocation of silence?
I wouldn't say automatically, but in this particular circumstance where there was an initial Miranda given, then at that point there was no questioning. It leaves a gap for the jury to fill in. And so that one bit of information that he didn't want to talk to the police, so we honored that and we took him down to booking, and then he was re-Mirandized. In that particular set of circumstances, it explains to the jury why wasn't he questioned right away? He was Mirandized.
But that's only because the gap is created because of the testimony that the prosecutor elicited. I mean, you could have basically just said, I took him down for fingerprinting, and at fingerprinting, he said X. The gap was created by you, or by your colleague.
But it was created by the fact that he was Mirandized twice. And the fact that he was Mirandized twice is relevant to the issue of voluntariness.
They're Mirandized twice all the time.
But
I mean, it's not at all uncommon for a defendant to be Mirandized at the scene of the arrest and then later at booking. And, I mean, this gap that you claim was created only because you elicited that testimony. I mean, it's not at all uncommon for there to be...
I think it was elicited in a temporal way. It explained...
Yeah, but you didn't have to do that. No, we didn't have to do that, but we explained in what other way would they say that he was Mirandized twice? I mean, he was Mirandized twice without any explanation. Well, I would say that in this situation, there would have been some confusion as to why he would have been Mirandized once, no questioning took place. He was taken down and booked, and a process went on, DNA was taken, a whole process went on, and then he indicated that he wanted to go back and speak to the police. If you just
And
play the devil's advocate.
Certainly.
If you wanted to, I mean, it happens a lot of times that there is some piece of inadmissible evidence that the parties have to make their way around.
yes,
A lot of times.
yes.
Well, one could look at this the same. You've got an invocation problem. You've got two Mirandas. You need to find a way around it. It's not impossible to do by any
It would not
stretch.
have been impossible. I will acknowledge it would not have been impossible to work around it. But in this case, I would argue that anticipating what was coming as well, the fact that that evidence came in without objection, the Commonwealth knew what the defendant was going to challenge. He had challenged it in his motion to suppress, and he had an expert who was going to give, well, I have not read the report precisely, but
Focus on the invocation by defense counsel during the motion to suppress.
yes, oh yes, during the motion to suppress, the fact that he invoked his right to counsel, it was very explicit. He went and made this phone call. There was a lot of timing and things. And then from that point, there was a lot of testimony about the defendant becoming more dope sick and what would happen to him. And then he, therefore, he wanted his medication. He would have been in a great deal of pain. And so the focus of the motion to suppress on the issue of his statement was he initially invoked, and then that invocation was not honored. It was overcome by the fact that he wanted his medication. And that's the reason that he then went and agreed to sign the form. It wasn't until after he was given his medication. So that was clearly an issue or an avenue that had been pursued by the defendant during the motion to suppress. There was no reason to assume that he wouldn't make the same arguments in the motion, during trial in challenging the voluntariness of that same statement. And that knowing that that was coming, the Commonwealth asked the question, there was no objection. The defendant then raises the issue as well.
Was this argued in front of, that was argued in front of the appeals court?
Yes,
All these facts came out?
Yes.
But that's not,
that's not
before us. We have limited FAR right here.
Right. No, I'm sorry. Yes, the motion to suppress was an issue before the appeals court, and it was fully argued and briefed there. Here, to my understanding, the only issue is the issue of the Doyle, the use of the defendant's silence during the trial. And the use of the silence was, I will grant you that the Commonwealth brought it up first, and there may have been a way to go around that. But in light of what happened during the trial, it was clear that this was going to come out. The defense attorney asked about it, asked Detective Dean about it. The defense expert testified that the fact that he invoked his right to remain silent was part of the foundation of his opinion, that he initially invoked, but because he would do absolutely anything to get his medication, he agreed to give a statement to the police.
But I thought that only came out on cross-examination. I didn't think that came out during the defendant's direct examination of his expert.
Right. The fact that he would do anything to get the medication came out.
That was on cross-examination.
Wasn't that on direct? I believe that was on direct. But the fact that part of the entire foundation of his opinion being based in part on the invocation came out on direct. I'm sorry, I'm cross-exam. So the fact that he would do anything to get his medication came out in a discussion of the voluntariness of that statement on direct. The prosecutor then examined the foundational bases for that opinion, and it included the fact, part of what shored up this opinion was the fact that he initially had decided that he didn't want to speak to the police. And then after that, he was so in need of this medication that he was willing to waive whatever rights and say whatever he needed to say to get his medication.
I can see why a defendant claiming lack of voluntariness would want to offer his initial denial into evidence, but I don't get why it helps the prosecution prove that it was voluntary. How does it help you to offer that?
Well, it helps us to put in the two Miranda warnings, and it helps us to show that he understood his rights.
Right, but you could have done all that without his invocation.
True.
Well, the fact that he invoked, I assume, means
Yes,
he understood what he was being told.
Yes, that he was able to invoke, and that he understood that he did not need to speak to the police, and that he did not need, he could request an attorney, which he also did. So the fact that he understood that he was able to exercise them, then went and again, as soon as he said that, it was honored by the police. The police took him down to booking, went on with the process, and thereafter, the defendant came to the police and stated that he wanted to speak to them, and the entire process was repeated again from start to finish.
Yeah, is there an issue here involving the so-called order of proof? And perhaps the Commonwealth should have asked the judge in advance for permission to do this. But if you didn't bring it out, would it have looked as if you were hiding something?
Yes, that would be a tactical decision by the trial prosecutor. It was not done. There was no offer at that point. But again, there was no objection from the defense attorney. It seemed to be, and it was a very experienced trial judge. So I would say that in this situation, it seemed very clear that this information was being used for this purpose. It was being used to explain why, what happened during the first interaction with the police. He was then taken down and given re-Mirandized a second time.
This is a little off that, but the hypothetical that the prosecutor posed to the expert, I believe, right? Was that a critical piece of this, of the use of this invocation?
The hypothetical itself.
I mean, because that certainly came out in the closing argument, and
Yeah,
it's part of what
I wouldn't say it was necessarily critical. It did bring out the fact that he invoked his rights to remain silent, and that he then later that would impact
that
his.
seemed to me to be front and central of her argument.
Well, it was of her closing argument. Well, the closing argument she made was in response, I would argue, to the defendant's closing argument, where he specifically stated that the defendant had the presence of mind to not speak to anybody, and then he was given medication and was then willing to give a statement. I would say that the prosecutor was responding to that direct statement by the defense attorney in his closing. And I know the light is blinking. Just in closing, I would like to say that even if this were a improper use of the invocation of his right to remain silent, the evidence under the 5 factors, if even just the one factor of sanity alone, the calculated nature of this attack, and I've listed everything in my brief for your review, would establish that there was no substantial risk of a miscarriage of justice in this case.
Thank you, Counsel.
Thank you very much.